Under Vehicle Code 23152, F, it is illegal to drive under the influence of any drug, including marijuana. The law does not require that you be drunk. It requires that the drug impaired your ability to drive safely. So the question is never just whether cannabis was in your system. The question is whether it affected your driving. With alcohol, California law sets a clear threshold, a blood alcohol level of 0.08%. Marijuana has no equivalent cutoff under California law. There is no number prosecutors can point to and say you were automatically too impaired to drive. That makes these cases more complicated for both sides. The prosecution has to build an argument around behavior and test results together, not a single number. If an officer suspects marijuana impairment, they will typically request a blood test because breath tests do not detect THC. A drug recognition expert called a DRE may also evaluate you. These officers are trained to look for physical signs like pulse rate, pupil size, and muscle tone. Their observations become evidence. The blood test result and the DRE report are usually the core of a marijuana DUI case. THC can remain in your bloodstream for hours or days after impairment has passed, especially in regular users. This creates a real scientific challenge. A positive blood test taken 2 hours after you stopped driving does not automatically prove you were impaired while driving. Defense arguments often focus on this gap between the presence of THC and actual, real-time impairment. Results vary case by case based on the specific evidence. A first marijuana DUI carries roughly the same penalties as a first alcohol DUI in California. That includes possible jail time, a base fine of several $100s that mandatory penalty assessments multiply several times over, probation typically lasting 3 years, and a required DUI program. A conviction also adds a point to your DMV record and can significantly raise your insurance rates. There is no promised result in any DUI case. Because there is no single number that defines impairment, marijuana DUI cases often turn on the quality of the evidence, the officer's observations, the DRE's methodology, and the reliability of the blood draw and lab analysis. California's Title 17 regulations, for example, set strict rules for how blood must be collected and stored. Problems in that process can affect how the evidence is used. Every case depends on its own facts. Marijuana DUI cases are genuinely different from alcohol cases, and understanding those differences is the first step to knowing where you stand. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.